Hey, so I wanted to just jump right into this Ninth Circuit District Court ruling from July. It's completely confusing. I made it 46 pages 2 nights ago and I'm just going to start at page 46 where I left off. Okay, so Johnson versus City of Grants Pass. Um, okay, and they're talking about whether or not you're homeless or involuntarily homeless. Under those cases, a person may not be prosecuted for conduct that is involuntary or the product of a status. See Martin 920 F 3D at 617 citation omitted. The city accordingly argues that sleeping is involuntary conduct for a homeless person, but that homeless persons can choose to sleep without bedding materials and therefore can be prosecuted for sleeping with bedding. Okay, pause. If Grants Pass was literally trying to make blankets illegal, this should be like blazoned across all newspapers for its lack of humanity. Like headlines, blankets illegal for homeless people. Like, no. And that's why there was this strong response in, I didn't realize that till 2 nights ago because I haven't studied this case, but it's largely cited. It's very pivotal and important that people like the Oregon Law Center and the ACLU are fighting for the homeless. In its order granting summary judgment, the district court correctly concluded the anti-camping ordinances violated the cruel and unusual punishment clause to the extent that they prohibited homeless persons from taking necessary minimal measures to keep themselves warm and dry while sleeping when there are no alternative forms of shelter available. The only plausible reading of Martin is that it applies to the act of sleeping in public, including articles necessary to facilitate sleep. In fact, Martin expressed concern regarding a citation given to a woman who had been found sleeping on the ground wrapped in blankets. 920 F3D at 618. Martin noted that citation as an example of the anti-camping ordinance being enforced against homeless individuals who take even the most rudimentary precautions to protect themselves from the elements. ID Martin deems such law enforcement unconstitutional. ID, it follows that city cannot enforce its anti-camping ordinances to the extent they prohibit the most rudimentary precautions. A homeless person might take against the elements. Footnote 28, Grants Pass is cold in the winter. The evidence in the record establishes that homeless persons in Grants Pass have struggled against frostbite, faced with spending every minute of the day and night outdoors. The choice to use rudimentary protection of bedding to protect against snow, frost, or rain is not volitional. It is a life-preserving imperative. The city's position that it is entitled to enforce a complete prohibition on bedding, sleeping bag, or other material used for bedding purposes is incorrect. The dissent claims we have misread Martin by completely disregarding the Powell opinions on which Martin relied, which make unmistakably clear that an individualized showing of involuntariness is required. Dissent 82. The dissent concludes that pursuant to Martin, the city cannot impose criminal penalties on involuntarily homeless individuals for sitting, sleeping, or lying outside on public property. Dissent 62. Thus, our purported complete disregard for Martin is not regarding the central holding that local governments may not criminalize involuntary conduct. Rather, the dissent believes, based on its interpretation of the Supreme Court opinions underlying Martin, that the Eighth Amendment provides only a case-specific affirmative defense that can never be litigated on a class basis. Dissent 59. To reach this counterintuitive conclusion, the dissent reads limitations into Robinson, Powell, and Martin that are non-existent. In Robinson, the Supreme Court struck down under the Eighth Amendment a California law that made it a criminal offense for a person to be addicted to the use of narcotics. Robinson 370 U.S. at 666. The law was unconstitutional, the court explained, because it rendered the defendant continuously guilty of this offense, whether or not he has ever used or possessed any narcotics within the state. 6 years later in Powell, the court divided 4-1-4 over whether Texas violated the Eighth Amendment under Robinson by prosecuting an alcoholic for public drunkenness. In a plurality opinion, Justice Marshall upheld the conviction of Leroy Powell on the ground that he was not punished on the basis of his status as an alcoholic, but rather for the actus reus of being drunk in public. Powell 392 U.S. at 535. 4 justices dissented in an opinion by Justice Fortes on the ground that the findings made by the trial judge that Powell was a chronic alcoholic who could not resist the impulse to drink compelled the conclusion that Powell's prosecution violated the Eighth Amendment because Powell could not avoid breaking the law. It at 569 to 70, Fortis J dissenting. Justice White concurred in the judgment. He stressed, if it cannot be a crime to have an irresistible compulsion to use narcotics, I do not see how it can constitutionally be a crime to yield to such a compulsion. At 549, White J concurring. However, the reason for Justice White's concurrence was that he felt Powell failed to prove his status as an alcoholic, compelled him to violate the law by appearing in public. It at 553, White J concurring. Pursuant to Marks v. United States 430 U.S. 188, 1977, the narrowest position which gained the support of 5 justices is treated as the holding of the court. In identifying this position, Martin held 5 justices in Powell gleaned from Robinson the principle that the Eighth Amendment prohibits the state from punishing an involuntary act or condition if it is the unavoidable consequence of one's status or being. Martin 920 F3D at 616, quoting Jones 443 F3D at 1135. Martin did not, as the dissent alleges, hold that Powell's controlling opinion was Justice White's concurrence. Dissent 60 C.Ed. 920 F3D at 616 to 17. It would have violated the rule of Marx to adopt portions of Justice White's concurrence that did not receive the support of 5 justices. The dissent claims Justice White's concurrence requires that the individual claiming a status must prove the status compels the individual to violate the law. Here, that each homeless individual must prove their status as an involuntarily homeless person to avoid prosecution. Footnote 29, the dissent's attempt to create a governing holding out of Justice White's concurrence is erroneous. By citing a word or two out of context in Powell's dissenting opinion, e.g. constitutional defense, our dissenting colleague argues both Justice White and the dissenting justices in Powell agreed any person subject to prosecution has, at most, a case-specific affirmative defense. Dissent 59 to 60, 77. We disagree. Though status was litigated as a defense in the context of Leroy Powell's prosecution, no opinion in Powell held status may be raised only as a defense. The Powell plurality noted trial court evidence that Leroy Powell was an alcoholic, but that opinion contains no indication status that may be invoked as a case-specific affirmative defense. As Justice White, the opening paragraph of his concurrence indicates, he was primarily concerned not with how a status may be invoked, but with the fact that certain statuses should be beyond the reach of the criminal law. If it cannot be a crime to have an irresistible compulsion to use narcotics, I do not see how it can be constitutionally be a crime to yield to such a compulsion. Punishing an addict for using drugs convicts for addiction under a different name. Distinguishing between the two crimes is like forbidding criminal conviction for being sick with flu or epilepsy, but permitting punishment for running a fever or having a convulsion. Unless Robinson is to be abandoned, the use of narcotics by an addict must be beyond the reach of criminal law. Similarly, the chronic alcoholic with an irresistible urge to consume alcohol should not be punishable for drinking or for being drunk. Whew. Wow, interesting. Powell, 392 U.S. at 548 49, White J concurring, internal citation omitted. Finally, neither a remainder of Justice White's concurrence. Okay, and then this footnote goes on. Nor the dissenting opinion explicitly states one status may be invoked as a defense. Rather, Justice White and his dissenters simply agreed that if Powell's status made his public intoxication involuntary, he could not be prosecuted. There is no conceivable way to interpret Martin as adopting our dissenting colleagues' position that one status must be invoked as a defense. But even assuming the burden must be placed on the party wishing to invoke a status, the class representatives establishing there is no genuine dispute of material fact that they have the relevant status of being involuntarily homeless. The law that the dissent purports to unearth in Justice White's concurrence is not the narrowest ground which received the support of 5 justices. No opinion in Powell or Martin supports the dissent's assertion that Powell offers exclusively an affirmative defense that cannot be litigated in class action. Dissent 59 to 77. All okay. And then we've got to go hit the 31, well, the 30 and the 31 footnotes. Federal courts have certified classes of homeless plaintiffs in the past. See Supernote 20, which counsels against the city's and dissent's position that such classes are impermissible under Rule 23. As noted above, Martin did not hold homeless persons bear the burden of demonstrating they are involuntarily homeless. See Supernote 29. Because the record plainly demonstrates plaintiffs are involuntarily homeless, there similarly is no reason for us to determine what showing would be required. We note, however, that some district courts have addressed circumstances in which the question of burden was somewhat relevant. CEG McArdle 519 sub 3D at 10:52, requiring, based on part of Martin, that officers inquire into the availability of shelter space before making the arrest for violation of the city's open lodging ordinance. Butcher v. City of Marysville, holding, Cal, February 27, 2019, holding plaintiffs failed to make a threshold showing of pleading that there was no shelter capacity, that they had no other housing at the time of enforcement. Dissent 5977, although the dissent might prefer that these principles find support of the controlling law, they do not. Okay, I'm going to stop there, but to describe what the heck is going on with this, basically look up Grants-Pass 9th Circuit, July 2023, and it's Gloria Johnson et al. Versus City of Grants Pass, number 20-35752, 9th Circuit 2023. Let's see, we'll just read the Justia summary so you kind of get a context. The City of Grants Pass maintains ordinances that preclude homeless persons from using a blanket, a pillow, or a cardboard box for protection from the elements while sleeping within the city limits. 3 homeless individuals filed a putative class action complaint against the city, arguing a number of city ordinances were unconstitutional. The district court certified a class of involuntarily homeless persons and later granted partial summary judgment in favor of the class. The district court issued a permanent injunction prohibiting enforcement against the class members of some city ordinances at certain times in certain places. Okay, the city appealed. In the amended opinion, the 9th Circuit affirmed in part and vacated in part the district court's summary judgment and permanent injunction in favor of the plaintiffs, affirmed certification of a class of involuntarily homeless persons, and remanded. The panel rejected the city's argument that the district court lacked jurisdiction because plaintiffs' claims were moot or because plaintiffs failed to identify any relief that was within a federal court's power to redress. The panel held that the district court did not err by finding plaintiffs satisfied the requirements of federal R. Civ. P. 23A such that a class could be certified under Rule 23B2. The panel affirmed the district court's ruling that the city of Grants Pass could not enforce its anti-camping ordinances against homeless persons for the mere act of sleeping outside with rudimentary protection from the elements, or for sleeping in their car at night when there was no other place in the city for them to go. Okay, so court description. Let's see, this is a bit longer. Civil rights, homelessness. The panel issued an order amending the opinion and dissent filed September 28, 2002, and let's see, reported at 54 F4th 787, filed an amended opinion and dissent concurrently with its order and denied a petition for rehearing en banc after a request for a vote on whether to rehear the matter en banc, and the matter failed to receive majority of the votes of the non-recused active judges in favor of en banc consideration, which I do understand district courts will have 3 judges on panel, but the, let's see, I believe it's Grants Pass wanted to have everything reheard in front of a larger panel, and they declined. And the matter failed to receive a majority of the votes of the non-recused active judges in favor, and that's what en banc means altogether, like the whole panel. Consideration, more than 3 judges. In an action challenging, The matter failed to, in an action challenging City of Grants Pass ordinances, which among other things, and denied a petition. Well, let's see. Filed dissent, denied a petition for rehearing. Let's see, challenging City of Grants Pass ordinances, which among other things preclude homeless persons from using a blanket, pillow, or cardboard box for protection from the elements while sleeping within the city limits. In the amended opinion, the panel affirmed in part and vacated in part the district court's summary judgment and permanent injunction in favor of the plaintiffs, affirmed certification pursuant to Federal Rule of Civil Procedure 23B2 of class of involuntary homeless persons, and remanded. The 5 municipal ordinances described as an anti-sleeping ordinance, 2 anti-camping ordinances, a park exclusion ordinance, and a park exclusion appeals ordinance result in civil fines of up to several $100s per violation. Persons found to violate ordinances multiple times could be barred from all city property. If a homeless person is found on city property after receiving an exclusion order, they are subject to criminal prosecution for trespass. The panel stated that the court's decision in Martin versus City of Boise, 902 F3D 1031, 9th Circuit 2018, which held that the Eighth Amendment prohibits the imposition of criminal penalties for sitting, sleeping, or lying outside on public property for homeless individuals who cannot obtain shelter, served as the backdrop for this entire litigation. Pursuant to Martin v. Boise, it is an Eighth Amendment violation to criminally punish involuntarily homeless persons for sleeping in public if there are no other public areas or appropriate shelters where those individuals can sleep. The panel first rejected the city's argument that this district court lacked jurisdiction because plaintiffs' claims were moot or because plaintiffs failed to identify any relief that was in the federal court's power to redress. The panel held that there was an abundant evidence in the record establishing that homeless persons were injured by the city's enforcement actions in the past, and it was undisputed that enforcements have continued. The panel further held that the relief sought by plaintiffs in joining enforcement of a few municipal ordinances aimed at involuntary homeless persons was redressable within the limits of Article 3. The death of class representative Deborah Blake, while the matter was on appeal, did not moot the class's claims as to all challenged ordinances except possibly the anti-sleeping ordinance. The panel vacated this, and that was partly because one of the class action participants was living in a car or a truck versus sleeping on the road. The panel vacated the summary judgment as to the ordinance and remanded to allow the district court the opportunity to substitute a class representative in Blake's stead. The remaining class representatives had standing to challenge the park exclusion, criminal trespass, and anti-camping ordinances. The panel held, based on the record of this case, the district court did not err by finding plaintiffs satisfied the requirements of Federal Rule Civil Procedure 23A, such that a class could be certified under Rule 23B2, although the city appeared to suggest that Martin's need for an individualized inquiry of each alleged involuntary homeless person's access to shelter defeated numerosity, commonality, and typicality. The panel held that nothing in Martin precluded class actions. And they're calling it Martin is the city v. Boise. We know it more as Boise because it was so pivotal when it came out. Let's see. Okay, let's see. Class could be certified. Let's see. The panel held that the district court did not abuse its discretion, including the numerosity requirement were met. The plaintiff's claims presented at least one question and answer common to the class, and that the class representatives' claims and defenses were typical of the class, and that they were homeless persons who claimed that the city could not enforce the challenged ordinances against them when they have no shelter. Addressing the merits, the panel affirmed the district court's ruling that the city of Grants Pass could not, consistent with the Eighth Amendment, enforce its anti-camping ordinances against homeless persons for the mere act of sleeping outside with rudimentary protection from the elements, or for sleeping in their car at night when there was no other place in the city for them to go. The panel held that Martin applied to civil citations, whereas here the civil and criminal punishments were closely intertwined. There was no need to resolve whether the fines imposed under the anti-sleeping and anti-camping ordinances violated the Eighth Amendment's prohibition on excessive fines, because the permanent injunction would result in no class member being fined for engaging in such protected activity. Finally, the panel held that it was unnecessary to decide whether the plaintiffs properly pled their procedural due process challenge to the Park Exclusion Appeals Ordinance, because subsequent to the district court's order, the city amended the ordinance. The panel directed the district court on remand to narrow its injunction to enjoin only those portions of the anti-camping ordinances that prohibited conduct protected by Martin, and this opinion, in particular, the district court should narrow its injunction to the anti-camping ordinances and join enforcement of those ordinances only against involuntarily homeless persons for engaging in conduct necessary to protect themselves from the elements when no shelter space was when there was no shelter space available. Dissenting, Judge Collins stated that Martin seriously misconstrued the Eighth Amendment and the Supreme Court's case law construing it. But even assuming that Martin remains good law, today's decision, which both misreads and greatly expands Martin's holdings, is egregiously wrong. Okay, and is this Justia's opinion? Although the majority's phrasing pays lip service to the fact that the persons at issue must be involuntarily homeless, the majority also explicitly regrets the city's contention that the holding of Martin can only apply after an individualized inquiry of each alleged involuntary homeless person's access to shelter. The net result for class certification's purposes is that any issue of individualized involuntariness is set aside, and Martin is thereby reduced to a simplistic formula to be resolved on a class-wide basis into whether the number of homeless persons in the jurisdiction exceeds the number of available shelter beds. And that's absolutely not dealing with shelters that are discriminatory. So that's another problem that's not really being brought up. The majority's analysis fails because Martin does not allow the individualized inquiry into involuntariness to be set aside in this way. Further, the majority opinion combines its gross misreading of Martin. This is Justia, guys, not me. Which a law website, which requires an individualized inquiry with a flagrant disregard of. And this is actually Justia explaining the dissent. Right? Okay. The panel held. There was no need to dissenting. Okay, yes. Into set aside. Further, the majority combines its gross misreading of Martin. This is the dissenting opinion, which requires an individualized inquiry with flagrant disregard of settled class certification principles pertaining to commonality under Federal Rules of Civil Procedure P23A and the requirements of Federal Rule. So Civil Procedure 23B, the end result of this amalgamation of error is the majority invalidates the core aspects of the district court's injunction in the case, which effectively requires the city of Grants-Pass to allow all but one of its public parks to be used as homeless encampments. In a joint statement regarding the denial of rehearing, District Judge Silver and Judge Gould wrote, Judge O'Scanlan's statement regarding the denial of rehearing and dissent from Judge M. Smith significantly exaggerate the holding in Johnson v. Grants-Pass. Grants-Pass, relying on Martin, holds only that governments cannot criminalize the act of sleeping with the use of rudimentary protections from the elements in some public places when a person has nowhere else to sleep. It does not establish an unrestrained right for involuntarily homeless persons to sleep anywhere they choose. Nor does it require jurisdictions to cede all public spaces to involuntarily homeless persons. Judge Silver and Gould also explained the class certification was proper, that the commonality requirement was met, that the majority applied existing Supreme Court and Ninth Circuit authority to the record represented by the parties, and that Judge O'Scanlan greatly overstated the extent to which Martin and Grants-Pass fall on one side of an existing circuit split. Respecting the denial of rehearing on bank, Judge O'Scanlan, joined by Judges Wallace, Callahan, Bay, Ikuda, who was in the Veritas decision, Bennett, R. Nelson, Bade, Collins, Lee, Brass, Forrest, Bumate, and Van Dyke, and with whom Judge M. Smith joins to all parts except Part 2A, states that with this decision, the circuit's jurisprudence now effectively guarantees a personal federal constitutional right for individuals to camp or sleep on sidewalks and in parks, playgrounds, and other public places in defiance of traditional health, safety, and welfare laws, a dubious holding premised on a fanciful interpretation of the Eighth Amendment. Judge O'Scanlan writes that the Boise panel made no effort to ground its decision in the text, history, or tradition of the Eighth Amendment. Unfortunately, the problems created by Boise have now been visited upon the city of Grants-Pass by the panel majority here, which has expanded Boise's faulty holding to infirm an injunction effectively requiring the city to resign all but one of its public parks to be used as homeless encampments. The circuit is the first and only federal court to have divined such a strange and sweeping mandate from the Cruel and Unusual Punishments Clause. The jurisprudence in this case is egregiously flawed and deeply damaging, at war with constitutional text, history, tradition, and Supreme Court precedent. And it conflicts with other circuits on a question of exceptional importance, paralyzing local communities from addressing the pressing issues of homelessness and seizing policy-making authority that the federal system of government leaves to the democratic process. Respecting the denial of rehearing on bank, Judge Graber agreed with the basic legal premise that the Eighth Amendment protects against criminal prosecution of the involuntary act of sleeping, but stated that the injunctive relief in this case goes too far. The extension of Martin to class-wide relief, enjoining civil statutes that eventually lead to criminal violations, but that have never resulted in criminal convictions for any named plaintiff, is a step too far from the individualized inquiries inherent both in the Eighth Amendment context and the context of injunctive relief. Even assuming that class-wide injunctive relief were available against a prosecution for criminal trespass, the Eighth Amendment does not prohibit all civil remedies that could, in theory, lead to such a prosecution. In this way, Johnson unjustifiably expands the reach of the Eighth Amendment, according to Judge Graber. Dissenting from the denial of rehearing on bank, Judge M. Smith, joined by Judges Bennett, Bumate, and Van Dyke, and with whom Judges Ikuda, R. Nelson, Bade, Collins, and Bress join as parts 1 and 2, stated that Martin cannot be squared with the Supreme Court's Eighth Amendment precedent, that the amendment to the original opinion is not accompanied by any downstream challenges to the majority's application of its rule to the facts or its ultimate conclusion, and that by wholly collapsing the merits into the class definition, the majority opinion certifies an impermissible fail-slave class. Local governments are hard-pressed to find any way to regulate the adverse health and safety effects of homeless encampments without running afoul of this court's case law, or at minimum being saddled with litigation costs. Judge M. Smith states that Martin, particularly now that it has been supercharged by Grants-Pass, has proven to be a runaway train that has derailed and done substantial collateral damage to the governmental units in which it has been applied and those living therein. These cases use a misreading of the Supreme Court precedent to require unelected federal judges, often on the basis of sloppy mixed preliminary injunction records, to act more like homeless policy czars than as Article 3 judges applying a discernible rule of law. Dissenting from the denial of rehearing en banc, Judge Collins states that the panel majority's joint statement regarding the denial of rehearing confirms and illustrates the layers of self-contradiction that underlie its opinion in this case, and that the panel majority is wrong to suggest that a newly enacted Oregon statute regulating the application of local ordinances to homeless individuals provides another reason not to rehear this case en banc. Dissenting from the denial of rehearing en banc, Judge Bress, joined by Judges Callahan, M. Smith, Ikuda, Bennett, R. Nelson, Miller, Bade, Lee, Forrest, Bumate, and Van Dyke, states that with no mooring in the text of the Constitution, our history and traditions, or the precedent of the Supreme Court, the court has taken our national founding document and used it to enact judge-made rules governing who can sit and sleep where, rules whose ill effects are felt not merely by the states, not merely by our cities, but block by block, building by building, doorway by doorway. Local leaders and the people who elect them must be allowed the latitude to address on the ground the distinctly local features of the present crisis of homelessness and lack of affordable housing. Not every challenge we face is constitutional in character. Not every problem in our country has a legal answer the judges can provide. This is one of those situations. Okay, so the big long thing is 155 pages, and I hope that explanation on Justia was helpful. What I feel is that the Americans are still not getting to a housing first perspective. They're still not looking at homelessness as something that should be an obsolete concept that is absolutely a violation of humanitarian principles. So while they negotiate where they can march people and which sidewalk they can sleep on and whether or not it's cruel and unusual to steal a blanket from a homeless person, it's I found that you really need a puke bucket next to your computer as you read this Grants-Pass decision, because it is so infuriating how Stone Age the mentality is and that we have to go through this. I still see it as progress. The glorious support. Let me go up to the front of the case here and explain who is like on their. Let me see if is it listed. Yeah, okay. So there's sort of like a table of contents of council. There's Capital Legal Services. Okay, and is this for Grants-Pass? Yeah, defendant. No. Okay. So I see it shifts. Okay. Georgetown University Law Institute for Constitutional Advocacy and Protection, Washington, D.C. for plaintiffs' appellees. Let's see. Homelessness Law Center, Washington, D.C. for amicus curiae, University of Miami School of Law of Human Rights Clinic, Homelessness Law Center. There's, let's see, Public Justice, Oakland, ACLU Foundation of Northern California, ACLU Foundation of Oregon, ACLU of Northern California, Southern California, ACLU of Oregon Institute for Justice, National Center for Law and Economic Justice, Rutherford Institute, National Coalition for the Homeless, Amici Curiae, National Homelessness Law Center, the Homeless Rights Advocacy Project of the Korematsu Center for Law and Equity in Seattle University School of Law, California State Association of Counties, California State Association of, let's see, and that's for League of California. I think that's actually probably for the defendants. Let's see, for amicus curiae City of Seattle. Yeah. Curiae for amici curiae. Well, that's a little confusing the way they have it indexed. It just would be easier if they completely separate, because it's kind of alternating apparently. Okay, so Alliance for Human Rights, historic. So it's basically city lobbyists versus human rights lobbyists, city and counties, and Hollywood Media District Property Owners Association. Interesting. Okay, and so the opinion filed September 28th, 2 was reported, has been amended. The petition for rehearing on bank is denied. Silver, the district judge, opinion. The city of Grants, so this is page 13. They really get going. The city of Grants Pass in southern Oregon has a population of approximately 38,000. At least 50 and perhaps as many as 600 homeless persons live in this city. Footnote. During this litigation, the parties have used different phrases when referring to this population. For simplicity, we use homeless persons throughout this opinion. And then they actually get into the difficulty with people who are couch surfing are still considered homeless, whether or not. So, and the number, anyway, so go check that out. Grants Pass business. I found a clipping in an old recycled newspaper from July and was like, oh, wow, I really should pay more attention to this, because I got the basic premise that you have to have an adequate shelter in order to offer these horrific tickets the police like to use to push the homeless around. And so my battle in my Astoria turf, which is our shelter system is not adequate, fair, and expansive enough to be inclusive to everybody, especially when we have Ozark excluding people on basis of discriminatory prejudices or personal difficulties. And that if we don't have actually fair, and like the Astoria Warming Center was notorious for having numerous people kicked out in the most horrendously cold weather. And it was almost like saying, we don't care if you die. And when Ozark denies meals, it's like he's saying, we don't care if you die. We don't care if you go hungry. We don't care if you're out in the rain. And that extreme policies they're having where they can't meet the needs of all the populations, or they punish people who bring forward concerns about food poisoning or mistreatment or theft or criminality, it makes it very hard for this ruling to even be useful, because the whole premise is there has to be available shelter. So I want to clarify for the city that available shelter cannot mean a discriminatory shelter, or a shelter that is constantly picking and choosing who they serve. And so how do I get that point across? It's kind of abstract, but it's very critical. And that's the first conversation I had with the police chief, is that Ozark, if he ever does open a lifeboat shelter down the basement, that is not accessible to the disabled, and it's not safe for women, and he persecutes women who go there. So it is not going to meet the requirements of this court to even enable the police to have ticketing. Okay,